Good on the judge for pointing that out. I think that's a fairly fatal error.
Yeah.
That notice is part of
I made her read it out.
It's part of the procedure and it's defective in its form.
G'day guys, just thought I'd do the shopping a little later today because we were in court yesterday challenging the speeding ticket, and I got the police prosecutor got told off, not doing his work properly, and I thought to myself, hello, so what's going on here? Now look at this slimy bastard, the same van that tried clicking me, EUR591. Sitting at the rise of a hill. Yeah, I'm going to drive slowly, mate, because you are a fuckwit. Because you are a fuckwit. Fuckwit. Sitting at the rise of a hill. Yeah, I'm going to drive slowly, mate, because you are a fuckwit. So, seeing as we've got this dickface here, who's parked right on this little rise, so people coming up over the hill don't see him, and people coming down this hill don't see him. He's trying to click people coming the other way. Sitting there with his car idling. So here we have EUR591. This is the vehicle they say back in April caught me on the motorway. Well, caught the car on the motorway doing 94 kilometers an hour in a temporary 80k area that the police can't even provide evidence of. I have found a fatal flaw in the speed camera tickets, and I figure, what better time than now to tell you all about it. Right, so there he is, EUR591, scumbag extraordinaire, Alan or Keith or whatever, they're all in there operating, probably asleep. So yeah, beware. Now the way the speed tickets work, in case you guys have been following my $80 speed ticket saga, what I've discovered is a fatal flaw in their procedures. You'll get your initial blue form from the Speed Camera Infringement Bureau telling you that you've breached. It'll say the type of offence, in that you drove a motor vehicle exceeding blah blah blah. And that's all it says. Now if you respond straight away to that first notice within 28 days, respond back to them asking for to be fully informed of the nature and cause of the allegations, they'll ignore you like they did with me. But I also in the first instance requested a court hearing. Now, because I requested a court hearing as soon as I got the first ticket, what happened is it then went straight across over to a notice of an infringement offence from the courts that got sent out to me. Now, normally, if you don't ask for a court hearing, they'll send you a reminder notice. And in the pink reminder notice, not only does it tell you what they're alleging, but it also tells you the provisions or the section of the Land Transport Act, section 40 and section 133 of the Transport Act that you've breached. On the charging document, those details must be on it. Now, on the Auckland District Court notice of infringement fee that I received from the police, and all I received back after requesting a court hearing was a photograph the letter I sent them and the notice of infringement fee saying that I had a time, date and place to appear at Auckland District Court. What it didn't have on it was the provisions, making it an invalid document. It's fraud. Because the police haven't informed you of the provisions under the Land Transport Act that you've breached, and because the notice of infringement fee, or notice of infringement offence that I was sent from Auckland District Court also didn't have the sections or provisions, I'm still wondering what I've done wrong. Now, I went in July and saw Judge Tim, and as we saw, he must have been suffering from a bad sexual experience the night beforehand, and Tim just yelled at me. He tried telling me that I've been informed, it's written on the paper, that's that. Now, Judge Nicole Mathers, who was the presiding judge yesterday on the 7th of November when I went in, I said the same things to her. I'd be happy to enter a plea provided I could be fully informed of the nature and cause of the proceedings. So she read out the notice in respect to an infringement offence that the Auckland District Court, and I showed her what I've been supplied. Now, the first letter I sent to the police was back on the 8th of May, after I got the ticket on the 29th of April. It was issued, and I think I received it on the 1st of May or 2nd of May. And I sent a letter in within a week, requesting to be fully informed, requesting for disclosure under Section 12, subsection 1 of the Criminal Disclosure Act, which means that they have to give you a summary of facts. It doesn't have to be signed, it's just a summary of facts, and on the summary of facts it also states the provisions that you apparently breached. Now, the police did not send me that. All they sent me was a photograph and my own letter back to me, along with that notice of infringement. Because I hadn't been informed on the original ticket, now bear in mind, on the reminder ticket, the provisions are labelled, so you are informed on the reminder, but you are not informed on the initial blue speeding ticket. Because I skipped the step and didn't ignore it, and didn't get sent a reminder, and because Auckland District Court's infringement notice asking me to appear for the preliminary hearing also didn't have it on it, and now according to the duty lawyer and the Amicus Curiae, it is a breach. It is a failure to follow due process of law. It's prosecutorial misconduct. Now, the prosecutor's busy saying, Your Honour, you know, this was sent out on the 30th of May, and I'm holding up what he sent me on the 30th of May, and he's trying to say that I got the summary of facts, and I got the witness list, and all of the provisions under Section 12.1 and 13.1 of the Criminal Disclosure Act that I should have been given, all of the information to be fully informed. I didn't. So, on the 15th of June, on the 23rd of July, on the 3rd of October, to auckland.pps, one of those two ones, to the address that they tell me on their cover sheet with the notice of infringement offence to talk to, I emailed that and I got absolutely no response. Not until mid to end of October did I actually get anything sent to me. And then they sent to me a notice of infringement. They sent me a brief of evidence from a non-sworn officer, in other words the camera operator. But they did not send me a summary of facts. They did not send me a witness list. Two things that I should have been given. The prosecutor's trying to say, Your Honour, for some reason, I don't know what he's done with them, trying to make out that he sent them to me. And because I continually, every month, sent letters back to the police asking them to please supply me that information, and I was specifying witness list, summary of facts, demerit point history, any notes made at the time of the infringement. Yeah, I asked for everything. In fact, that back in 2015 when I challenged it, they supplied me the whole lot. So because they supplied me all that time, I just looked at the file they supplied me that time, and I just took note of everything they supplied me, and I asked for that again. The prosecutor and his boss, because he was somewhat getting racked over the coals by the judge, decided they'd ring up Wellington. And Wellington saying, oh, it was sent to him, but we can't prove it, he's lying. That's what the prosecutor's boss told him. He rung up Wellington. They said, oh, no, sure we've sent it to them, but they can't prove it. Now, something sent in the post is considered sent unless you object to it. Because he was trying to say I had been fully informed, and I objected, and I had 4 letters dated after the fact that I apparently had received these things, asking for these things still. I clearly just said to the judge, Judge, why would I still be asking for these things if they've already supplied them? Which they haven't. Then the prosecutor tries to actually hand me the summary of facts, and still haven't got a witness list, tried to hand me the summary of facts and everything else there and then. No. It's abuse of court process. You can't just give me them there and then, and I'm supposed to understand them without being able to even review or look at them. There's no reasonable time to review the evidence or their allegation or the provisions that should be listed for me to be able to comprehend and be fully informed. So he then said, Your Honour, you know, and because I had shown Nicole the copy of these 4 letters, she was then somewhat leaning towards me on what I was telling her. The prosecutor then tried to say that I had no proof that I'd sent the prosecution these things. Well, of course I objected again. Your Honour, I actually had printed out the email with the 15th of June letter, it may have been, I think, one of them, showing that I'd sent that letter on that date. And then I said to Your Honour, I have meticulous records. Everything was sent through email, and it was only after I found a secondary prosecution's email address in October, and I sent it to more than one prosecution email address, that I actually got a fucking response. Prosecution saying, well, it's not our fault if he's sending it to an address we don't check. Well, if it's an address you don't check, don't write it on there. If you need to correspond to us, email us here. Don't write it there if you don't fucking check your emails, cops. Get your ducks in order. Follow your rules. Follow your Crown procedures. Follow your summary procedures. It's real simple. You got rules to follow. So do it. So, it's been adjourned. On the 9th of February 2018 at 9:30 at Auckland District Court, I'm going back before Nicole Mathers, the judge again, because she appointed an amicus curiae to help her, because the amicus curiae, being a lawyer, is there to help her with the law. He's not there to help me. Every lawyer's first duty is to the court, not to the client, not to the plaintiff, not to the defendant. It's to the court. So after I put a couple of the lawyers in their place, letting them know exactly what the go was, and earning their respect in the process. In fact, one of them, who'd been practicing law for 50 years, after knowing and speaking to me for 3 to 5 minutes, said, we need more people like you. He wondered why I was questioning an $80 ticket. I says, because I don't care if it's for 1 cent, they have to prove it. And it's a criminal allegation, which means it's not just a preponderance of evidence. They have to prove every element of the crime beyond a reasonable doubt. Now, there's a breach in procedure. They haven't supplied me the information I'm supposed to be supplied under their own criminal disclosure rules. Now, it's taken 9 months. It's going to be, well, 8 months by the time we actually get through to hearing this. And they only have 12 months tops to complete the arraignment. I haven't even gone through to a defendant hearing yet. I told the judge I would be more than happy to enter a plea if I could be fully informed first. Because she read that out and she noticed they hadn't put the provisions on there, she started racking the prosecutor over the coals about it. So, All I have to do, and I've already done it, is print out the actual emails showing that on the 15th of June, 8th of May, 23rd of July, 3rd of October, which I have already done and highlighted and sent to the Amicus Curiae and to Rita, along with a request for the court transcript of yesterday as well, because it's a beauty. All I have to do is produce that, and that shows that I have been repetitively asking without any reply. And on my letters, I put notices on the bottom. Failure to respond shall constitute a tacit agreement. Failure to respond shall be construed that New Zealand police don't have any evidence, and they don't respond. Although they are responding by not responding. They're giving me passive acquiescence. They're agreeing to what's on my letters. They might talk to the blue in the face and say they haven't received them. I can prove through my emails that that was sent to them. And the judge will dismiss the case because they have failed. It's a breach of process and they have failed to do their own rules. The Amicus Curiae said this happens a lot. So if you want to beat a speeding ticket, don't wait for the reminder. As soon as you get a ticket, request a court hearing. When they send you the notice of infringement fee, and if it doesn't have the section or provision of whatever law it is that you're supposedly broken, or legislative rule that you've breached, then they are committing fraud. They are trying to serve you an invalid document, passing it off as legit. Naughty. So people, next year, this is if the police prosecutions choose not to withdraw their fucking bullshit beforehand, and I'm talking to you, Sergeant, yesterday, or you, Vicky. If you choose not to withdraw it, guess what? I'm going to be setting a case law precedent. Police v. Keane, 2008, where you guys can't even follow your own procedures properly to fully inform anybody. And the prosecutor goes, when the judge points this out to him, the prosecutor goes, well, that's just standard, it's the way we do things, everybody just normally pays. Everybody in the courtroom's jaw hit the floor. So you've been doing this to everybody. I personally reamed out the prosecutor before the court was back being heard again, before the judge was back. I personally reamed the living shit out of the prosecutor, told him and the rest of his buddies in his club that he should get his ducks in order and his shit together, and I hope you're going to be giving a lot of refunds to people that you've committed fraud upon. But we'll deal with that as we go. So I'm extremely pleased that I have nailed these fuckers to the floor. I'm chuffed. Now, I held the judge to her oath, just for simply asking, Your Honour, are you going to be acting in a fair, impartial and independent manner today? There's not going to be any collusion going on. This is all in the transcript, which I'll happily show you guys. Because she said, yes, Mr. Keane, there's going to be no collusion, I held her to her oath. She couldn't play buddy-buddy with the prosecutor. And then she reamed him out. Told him to go check section 21 of the Summary Procedures Act. Rule 2.1. Section 241, I think, was the other one. I've read them. Naughty, naughty prosecutor. You would think that if these pricks are making so much fucking money out of us each year, that someone might have picked up on this. But no. I've gone back and I've looked at my other infringements and speeding tickets that have been sent to me over the years. One in 2009, one in 2011. I have blue and pink copies. The blue copies do not have the provisions on them. It is only when it hits the reminder stage that they put those provisions on there. That's fraud. You are not being fully informed on the first ticket what provisions you're in breach of. And because I asked for the hearing straight away and didn't get the reminder, and because the cops were too busy sucking each other's fucking dicks off, they just thought to ignore my repetitive requests for the information that I hadn't received. Bit of a bad move on their half. So guys, that's the update of what happened yesterday. I find it only fitting to be doing this across the road from that piece of shit EUR591 that is sitting here. Not, yeah, it's 250, 300 metres of a straight road, but as I've just shown you, and I'll show you again, he's parked there. That's not 250 metres viewable distance. People are coming up over that rise, and boom, he's getting them if they're doing, he's getting them instantly if they're doing over the speed limit. That's entrapment, people. Bear in mind that the mufti vehicles will rake in, on average, 7 times more tickets daily than a marked police vehicle, police surveillance vehicle can do, because people don't know they're speed cameras. So, be wary, people. I would suggest that you all keep close interest in what's happening next time. Because, yeah, it's going to be very interesting. And if this judge dismisses the case with extreme prejudice because the prosecution committed misconduct by not supplying the defendant with the information so he could be fully informed, which is a breach of their Summary Procedures Act and their criminal procedures, then that's case law, people. You guys can use that, if it happens to you, as case law precedent for it to be instantly thrown out. That is how you beat any Schedule 1 or Schedule 2 traffic infringement offence or moving vehicle offence. That is how you do it. You make them produce the information, and when their incompetent shit-ass fucking gang called the New Zealand Police fail to do their job properly, and let's bear in mind here, all day yesterday I had the speed camera operator, when I showed up there yesterday morning, he was asleep sitting outside the courtroom. He was dressed like a bum, and he was supposed to be a New Zealand Police employee in an old puffer jacket and scruffy jeans. He was dressed like a grumpy old piece of shit, and I had to have him sitting in that courtroom till at least 3:30 in the afternoon. He may be getting paid $50 for the day for appearing as a witness for the prosecution, but he wasn't on the road earning $108 on average minimum per minute ticketing people. And that's going by the facts that they have presented to me in the deployment register. He is not on the side of the road issuing tickets. He is sitting in a courtroom, bored fucking shitless, not raping and pillaging people. The lawyer said there needs to be more people like me, because if all of us stood the fuck up and started questioning this shit instead of just giving them your hard-earned fucking cash, they would be overrun and fucked properly. So, go ahead. Just pay the fine, or if you have a look between your legs, men, you might find something that might want you to do something different. Women, you might find a set too. Don't accept fucking nothing. You're reading what you believe to be English on a legal document. It is in a different language, and I haven't even got to a defendant hearing stage. Shit, if it actually goes through to a defendant, if she chooses not to throw this matter out straight away and it goes to the defendant hearing, I've got at least 50 fucking questions lined up to ask this piece of shit. Like, do you have any first-hand personal knowledge that I was actually operating the vehicle that day? because there's more than one registered owner. The Amicus Curiae said to me, oh, well, they can just withdraw that charge and then charge your wife, who's the dual owner or second owner. Really? No, they can't, because that was in April. They only have 6 months to start proceedings, and it's been at least 7, coming on 8. So they can't change it and reassign it, because they're that slack. So, good news, people. I hope you comprehend what I'm trying to tell you, that all you have to do as soon as you get a speeding ticket, before they have a chance to send you the reminder, is to request to be fully informed of the nature and cause of the proceedings. When they send you a photo and a notice of proceedings from the court that they want you to appear in, and if that notice doesn't have the provisions of this Section 33 or Section 30 or Section 140 or whatever the fuck it is of the Land Transport Act marked on it, it is an illegal, invalid and fraudulent document that they are passing off as legal to scare you into paying. They're using your own ignorance to milk you blind. You know? I hope this helps you guys, I really do. I'm doing this again just for shits and giggles. I have never seen a judge ream a prosecutor like that before, and I've never had the fun of being able to ream the living shit out of the prosecutor personally myself either, like I did yesterday. Now, granted, the proceedings weren't actually happening when I recorded those things, so I haven't really done anything naughty in their book, because court was not in session. I was not recording then, or was I? Brian had to come in and check my phone before the hearing yesterday. He even had to push a couple of buttons after asking me for permission first to make sure my phone was off. You know, when you step out of the courtroom, you do have an option to turn your phone back on and make a phone call. People are coming in and out of the courtroom. There's a possibility they may turn on their phone again. There's a possibility they may record. Anything is possible. At the same time I was reaming out the prosecutor, I gave old Brian a bit of grief too. Reamed him out a little bit in the nicest possible way. I told Brian, mate, have you read the comments people are saying about you on these clips? Mate, I stick up for you. I tell them you're just a brown coat. You don't know. You're just doing your job. Criminals have jobs to do too. I comprehend, mate. I stick up for you. His face was priceless. And I'd like to say a special thank you to the lady that went out of her way, walking kilometres from free parking to attend yesterday, to just to watch. There's nothing better than knowing that you're not the only one in that courtroom. You don't feel ganged up on, even when you have a silent witness in the background or someone who's just come to have a nosy. And I'd like to thank her personally, and also for the lift that she gave me after the hearing back out towards my way, given that my radiator in the car blew up on the way to court. I was lucky to make it there in the first place, and I was very thankful for her assistance and help, and I absolutely adored the conversations we had between them, you know, the hearings. It was really awesome, and I thank her for it. So if you're listening, and I'm sure you're probably watching, thank you again, and hopefully I'll look forward to seeing you again in February. Hopefully you'll be there with bells on, because I will be. The stuff they were asking for, I've already sent it to the court and to the Amicus Curiae. I'm not going to bother sending it to the prosecutor, because they've already got it. And if they say they haven't, I can prove they're lying. Okay? Until we chat again. It was a bit of a lengthy one, this one, guys, but I hope you enjoyed it. I would post what I have, but I'm not going to, you know, look a gift horse in the mouth. I'm just going to bite my tongue and bide what I have. And I will show you a few things, just so you can all have a laugh and listen to what happens. A bit of reaming, I'll post that for you, because court wasn't in session. But yeah, anything else I may have, I'll wait until after this matter's resolved first. Don't want to cause any prejudice, do I? So, yeah, I'm absolutely wrapped. And all of this is for an $80 ticket and $30 court costs. Sure, they turn around and say, I could get fined up to $1,000 for this. Really? The prosecutor could get done for prosecutorial misconduct and fraud for not doing their shit properly. $1,000 worth it. And I'll just pay that off out of the SEST-AQV, the SEST-AQ trust that all you taxpayers pay for. Idiots. I asked the Amicus Curiae, mate, we live in a voluntary society, don't we? He goes, no. So what are you, just a slave? He didn't like those answers, but by standing my ground and showing my knowledge, I earned their respect pretty much instantly from the duty lawyer that quickly spoke to me and from the Amicus Curiae, Roger Chambers. Thanks, Roger. Yeah, anyway, I'm now at Pack and Save. I'm in the grandmother's car, radiator sitting there behind me. Just had to go and get that sussed out, get a new one tomorrow or sort out another one tomorrow, and we'll be back and running. So yeah, so all those people out there that have been following this, thank you very much for following and supporting this. It ain't over yet. They didn't even get a play. We didn't address the motions that I filed. I filed a motion to have it dismissed because of failure to provide subject matter jurisdiction, motion to dismiss due to lack of personal jurisdiction, motion to have Judge Black's plea struck that was entered because it was done so without my intent, direction and wishes, which was brilliant. But we can't even get past the fact that the prosecution didn't supply their shit properly. They didn't do their paperwork well. Thrown out. Thank you so much, Crown Prosecution. You had ample time and ample opportunity and ample requests to give me what I was entitled to, and you fucked up. So, boo-hoo. I'm sorry, I sound sarcastic. It's been a long day. My brain's still in law mode, so it's all still fresh in my head. So I thought I'd let yous all know. I was pretty exhausted when I got home last night. I still had to cook tea for 6 people. I was cooking for 2.5 hours. So anyway, guys, much love to you all. Stay golden. Don't let the fucking system bring you down. Stand up to it. Get some knowledge. Don't just accept what's given to you as fact. Always ask for evidence, because it's all assumption and presumption absent fact. And if a traffic infringement is a criminal offence, they have to prove beyond the reasonable doubt everything. It's that simple. See yous.